My parents offered me $3 million to hand over my 6-year-old daughter. They called her the golden child, like she was a coin they'd minted themselves. I said no in the driveway of my own house, standing next to a truck with a check engine light that had been on for 4 months, and 40 minutes later my father called his lawyer. What none of them knew was that my 13-year-old, Chloe, had already started recording. Every text. Every voicemail. Every bribe. Today in family courtroom 4B, a judge named Evelyn Mercer isn't just hearing a custody case. She's about to read messages my parents thought they deleted, and by the time she's done, my family as I understood it will not exist anymore. My name is Julian Vance. I'm 39 years old, and 11 months ago I buried my wife, Renata, on a Tuesday in March at Glenhaven Cemetery off Route 9 in Danbury, Connecticut. The funeral cost $6,200. I know that number because I still have the invoice from Hendrick's funeral home taped inside a kitchen cabinet, next to the one for Lily's kindergarten registration. I keep both because I need reminders that I've survived worse math than what's coming. I work as a maintenance supervisor for a commercial property group off Federal Road. I make $61,000 a year, enough to keep the lights on, mostly enough to keep Chloe in soccer cleats, and nowhere near enough for the kind of lawyer my parents can afford by lunchtime on a Tuesday. Here's what I need you to understand first: I am not a perfect father. I forget permission slips. I let Lily eat cereal for dinner more nights than I'd admit to a social worker. I snapped at Chloe in February when she asked why we couldn't get a new couch, and I said something about her mother I regret to this day. I am tired in a way that doesn't have a name yet. But I show up. Every practice, every conference, every 2 a.m. fever. That's the only credential I walked into that courtroom with, and my parents' attorneys tried to make it look like nothing. My parents are Arthur and Evelyn Vance. Arthur built a chain of regional insurance brokerages starting in 1987, and sold the majority stake in 2019, for a number he still won't say out loud in front of me, though Danbury property records show the house on Ridgewood Lane alone is assessed at $2.1 million. Evelyn sits on the board of 2 charitable foundations, and has never once asked me a question about my day that didn't circle back to how I was living it wrong. They loved Renata. That matters because it's the hinge everything else swings on. Renata was the daughter-in-law who made them look generous in front of their country club friends. She came from nothing, they'd say, like it was a compliment, dismissing the nurse practitioner degree she earned working night shifts. When she died of pancreatic cancer, caught in October and gone by March, my parents didn't grieve her so much as they audited the situation. Within 3 weeks, my mother was in my kitchen with a legal pad. "You cannot raise 2 girls alone on a maintenance man's salary," she told me. She used the phrase maintenance man twice in one sentence, which I noticed even through the fog of losing my wife 5 weeks earlier. I still get the math wrong sometimes. That's how new the wound was. Lily was 5 then, now 6, and she has Renata's exact laugh, a hiccuping giggle that made strangers in grocery stores turn around and smile. My mother has never once said this about Chloe. Chloe was born from my first relationship, before I met Renata, and my mother has spent 13 years finding small, deniable ways to remind everyone that Chloe is not, in her words, blood in the same way. I want to be precise, because precision is the only weapon I have against people with better lawyers than me. My mother never said Chloe wasn't her granddaughter. She said things like, "It's just easier to connect with Lily, isn't it?" at Thanksgiving, in front of 11 relatives, while Chloe stood 4 feet away holding a serving spoon, old enough to understand exactly what was being said about her. The offer came on a Thursday, April 9th, the day after Lily's kindergarten spring concert, where she sang, "You Are My Sunshine," off-key, and Chloe filmed it because I'd forgotten to charge my own phone. My father called that evening and asked to come by to talk business, strange phrasing for a man calling about his granddaughters. He arrived at 7:15 p.m. in a navy suit, carrying a leather folio. My mother came uninvited, wearing the composed sympathy face she uses for other people's funerals. They sat at my kitchen table, the same table Renata and I bought secondhand off a Danbury Facebook group for $80, and my father opened the folio like he was closing an acquisition. We want to formalize something, he said. For Lily's future. He slid a sheet across the table. Not a contract yet, just a summary prepared by Rosalind Ferris, ESQ, of Ferris & Kane, a firm specializing in guardianship transfers for high-net-worth families. It proposed Arthur and Evelyn assume full legal guardianship of Lily Renata Vance, citing her unique developmental needs and the financial instability of the current household. In exchange, a one-time payment of $3 million, structured as a trust disbursement, contingent on my consent and my agreement not to contest the guardianship in court. I asked them to leave. My mother said I was being emotional. My father said the offer wouldn't remain open indefinitely, as though my daughter had a market value with a countdown clock attached. What they didn't say, what I didn't learn until 11 days later, from a source I never expected, was that they were already in contact with a court-appointed evaluator named Marisol Ackerman. According to a text later pulled from Evelyn's phone, my mother had asked Victoria, my younger sister, whether Ackerman could be reasoned with. I need to tell you about Victoria, because she's the reason this never stayed contained to a kitchen table. Victoria is 34, my only sibling, and has spent a decade positioning herself as the responsible Vance child, Boston College, married to a cardiologist named Preston, the one my parents call thriving at parties. What almost no one outside our family knows is that Victoria is named primary successor trustee of the Vance Family Trust, a role granting expanded authority over any minor beneficiary who resides with a trust-designated guardian. Lily was set to inherit $800,000 at 18. If Lily lived with my parents, Victoria, as successor trustee, controlled those investment decisions for 12 years. If Lily lived with me, Victoria controlled nothing. I didn't know any of this on April 9. I only knew my parents wanted my daughter, and were treating it like a real estate closing. 5 days later, April 14, I received a certified letter from Ferris & Kane. Not a settlement offer anymore, a petition for emergency custody, filed in Connecticut Superior Court, Fairfield County, docket number FA 25-0392817-S, alleging Lily Renata Vance was at substantial risk of harm in my care due to financial instability, inadequate supervision, and an unsafe home environment. I read that petition standing in my own driveway, next to a mailbox with a dented flag, and felt something in my chest I can only describe as the floor disappearing. They'd turned a money conversation into a war conversation in 5 days, in writing, under oath, which meant they now had to prove it. Here's the thing about people who've never had to fight for anything, they forget a fight leaves a paper trail. My parents were about to generate hundreds of pages of texts and sworn statements, all built on lies they assumed no one would ever see. They didn't count on Chloe. I was so consumed with finding a lawyer I could afford, I eventually found Denise Okafor, a family law attorney taking mostly pro bono cases out of a converted retail space in Bethel, that I didn't notice my older daughter acting differently. Quieter at dinner. On her phone more but not scrolling. Typing, with a focus I mistook for homework. It wasn't homework. On the night of April 22, 8 days after the petition landed in my mailbox, Chloe knocked on my bedroom door at 11:40 p.m., holding her phone with both hands like it might spill. "Dad," she said. "Grandma's been texting me." I sat up. "About what?" Chloe walked over, sat on the edge of my bed, and turned the screen toward me. A message thread I didn't know existed, dated April 10, the day after my parents' kitchen table offer. The first message, from my mother's number: "If you help us with Lily, we'll make sure you get into Brent Moore Academy next year. Full tuition. You know your father can't afford anything like that for you." I felt sick reading it. Brent Moore is a boarding school outside Hartford with tuition north of $50,000 a year, the kind of school my mother mentions at every birthday, always followed by a look in my direction. "There's more," Chloe said quietly. I started saving everything. Screenshots. I backed it up before she could delete anything, because last year Grandma showed me how iMessages disappear if you unsend them fast enough. I didn't tell you because I wasn't sure it mattered, and then I got scared it mattered too much. I looked at my daughter, 13 years old, still in her soccer jersey, holding evidence in a custody war she never asked to be part of, and understood two things at once. I had underestimated how far my parents would go. And Chloe had been carrying this alone for 2 weeks, because she didn't trust the adults around her to protect her if she spoke up. That is the moment this story actually begins. Not the kitchen table. Not the petition. This moment, in a dim bedroom at 11:40 p.m., when a 13-year-old decided she wasn't going to let her family be bought or restructured without a fight, with no idea how much worse it was about to get, because 3 days later, a second thread would surface, this one between my mother and Victoria, discussing a court evaluator, a payment, and a report that hadn't been written yet but had already been decided. 3 days after Chloe showed me the Brent Moore Academy texts, a second phone lit up at 6:52 a.m., not mine, not Chloe's. Lily's tablet, the one she uses for reading apps, synced to a shared iCloud account my mother had insisted on setting up for photos back when Renata was still alive. A notification banner slid across the lock screen from a thread labeled Mom, my mother's contact name, saved under Victoria's account, which had somehow bled into the shared family cloud through a backup neither of them thought to check. I wasn't supposed to see it. I saw it anyway, standing in my kitchen in a t-shirt, coffee going cold, at 10 minutes to 7 on a Wednesday. Evelyn to Victoria, 11:47 p.m. the night before, Ackerman wants 10. I told her we'd wire it through the foundation as a consulting fee so it doesn't trace back to the petition. Make sure Julian's file mentions the missed dentist appointment in January, and the time Chloe walked home alone from the bus stop. We need at least 3 specific incidents for the report to hold up. I read it twice standing in that kitchen, and then a third time, because part of me was looking for a way to misread it. There wasn't one. Marisol Ackerman was the court-appointed evaluator assigned to my case by Judge Mercer's clerk on April 19, supposedly at random from a rotating list of licensed family evaluators in Fairfield County. My parents were paying her $10,000, laundered through the Vance Family Foundation as a consulting fee, to write a report that would say I was unfit before she'd ever set foot in my house. I called Denise Okafor before 8. She told me to screenshot everything, timestamp it, and not confront anyone yet. The second they know you have this, she said, they'll destroy every other copy and claim the whole thing is fabricated. You need more than one thread. You need a pattern. I didn't tell her Chloe already had one. I hadn't told Denise about Chloe's flash drive yet either, because a part of me, the part that still wanted to believe my parents had a floor they wouldn't go below, was hoping I wouldn't need it. Ackerman's home visit was scheduled for May 2nd. In the 11 days between the tablet notification and that visit, my parents shifted tactics in a way I didn't fully understand until much later, when Denise laid the pattern out for me on a legal pad of her own. They stopped trying to prove I was dangerous. That angle was too easy to disprove, no police reports, no CPS history, no incidents beyond the ordinary chaos of raising 2 kids alone. Instead, they started building a case that I was simply insufficient. Tired. Stretched thin. A man doing an adequate job when Lily, specifically, deserved more than adequate. My mother began showing up unannounced. April 24th, she arrived at Lily's school during pickup, 10 minutes before I did, and told the front office she was helping with transportation today, which wasn't true, and wasn't authorized, but the substitute teacher covering dismissal didn't know that. Lily was already in the car, buckled into a booster seat that wasn't hers, when I pulled into the lot and saw my mother's Lexus in my usual spot. She seemed confused waiting for you, my mother told me, calm as anything, when I asked what she thought she was doing. I didn't want her standing there alone. Lily hadn't been alone. Lily had been standing with her teacher, exactly where she was supposed to be, for 4 minutes before my mother intercepted her. But now there was a version of that afternoon, the one my mother would later describe to Ackerman, where a 6-year-old, stood unsupervised outside a school building while her father was late. I want to pause here because this is the part of the story people misunderstand about manipulation inside families with money. It doesn't look like a threat. It looks like help. My mother wasn't trying to look cruel. She was building a record, one small manufactured crisis at a time, each one innocent enough on its own that I couldn't call the police, couldn't get a restraining order, couldn't do anything except stand in a parking lot feeling my own daughter get used as evidence against me. Chloe noticed before I did that something had shifted with her, too. My mother stopped mentioning Brent Moore. She stopped texting about tuition. On April 28, a new message arrived, and Chloe showed it to me the second she read it, no hesitation this time. She'd learned, faster than I had, that hesitation was the expensive part. You need to understand something, Evelyn wrote. If your father loses this case, which he will, you and Lily will be separated permanently. Lily comes to us. You go into the foster system, because your father won't be able to afford a place big enough for you once he's paying his legal fees. I am trying to protect you from that. Help me help Lily, and I promise you won't end up in foster care. It wasn't a bribe anymore. It was a threat dressed as concern, and it was aimed at a 13-year-old, and it was a lie. Chloe was never at risk of foster care, not while I was alive, and not accused of anything remotely close to abandonment, but my mother knew Chloe didn't know that, and she used the gap in a child's legal knowledge as a lever. I filed a police report that afternoon, not because I thought it would lead anywhere immediately, but because Denise told me documentation now would matter later, and she was right, though I didn't understand how right until the hearing. The responding officer, a patrolman named Officer Reyes, took my statement, photographed the messages on Chloe's phone with her permission and mine, and told me plainly that harassment of a minor, even by a grandparent, even without physical contact, could constitute a basis for a restraining order if it continued. It continued. May 2nd arrived. Ackerman's visit was scheduled for 4 p.m., a Friday, and I'd spent the 2 days before it cleaning a house that was already clean, buying groceries I couldn't quite afford so the refrigerator would look full, and rehearsing answers to questions I hadn't been asked yet. Denise warned me not to over-prepare. Evaluators can tell when a house has been staged, she said. Just be a normal, tired dad. That's your defense. Normal and tired is not the same as unfit. Ackerman arrived 4 minutes late, carrying a tablet and a canvas bag, and she was polite in the specific, careful way of someone who has already decided something and is documenting toward a conclusion rather than forming one. She asked Lily to draw a picture of her family. She asked Chloe, separately, in the kitchen while I waited in the living room, whether she ever felt scared at home. I don't know exactly what Chloe said in that conversation. I know that when Ackerman left, 40 minutes later, she thanked me for my time in a tone that told me nothing, and that Chloe came out of the kitchen with her jaw set in a way I recognized from every hard conversation Renata and I ever had about money. She kept asking if you leave us alone a lot, Chloe told me once the door was shut. Like, alone. I told her you've never left us alone overnight in our whole lives. She wrote something down anyway. 9 days later, on May 11th, Ackerman's report arrived in Denise's office, forwarded from Ferris and Kane, with what Denise described as unusual speed for a court evaluator with a full caseload. It ran 14 pages. It cited the school parking lot incident, reframed as a pattern of inconsistent pickup supervision. It cited the January dentist appointment I'd missed, the exact incident named in the tablet text 3 weeks earlier, word for word, down to the date. It concluded that while I was not abusive, my household presented elevated risk factors related to financial strain and inconsistent structure, and it recommended the court consider transferring primary custody of Lily Renata Vance to Arthur and Evelyn Vance, with a graduated visitation schedule for me to be determined later. I sat in Denise's office reading that recommendation with Chloe's flash drive sitting in my jacket pocket, untouched, still unmentioned to my own lawyer, and I understood for the first time that I wasn't going to win this by being a good father. Good had never been the test. My parents had built an entire case designed around a version of good they controlled the definition of, and the only thing that could break it wasn't my parenting record. It was proof of exactly how they'd built it. Denise, I said, there's something I haven't told you about my daughter. Denise didn't say anything for almost 30 seconds after I told her about the flash drive. She just held out her hand, palm up, across her desk, the same way you'd ask for keys from someone you didn't trust to drive. I gave it to her. She plugged it into a laptop that wasn't connected to the office Wi-Fi, which she explained later was standard practice for anything that might become evidence. Chain of custody mattered, and so did making sure nothing on that drive ever touched a network my parents' lawyers could later claim had been tampered with. There were 211 screenshots, 14 voice memos, 6 saved email forwards Chloe had somehow gotten access to through a family iCloud login my mother had set up years earlier, and never bothered to remove her from. Denise read through the first 30 screenshots in silence, her jaw tightening in stages, the way a person's face changes when they're recalculating something in real time. "Julian," she said, "why didn't you tell me this existed 3 weeks ago?" I didn't have a good answer. I told her the truth, which was that some part of me had been protecting Chloe from becoming the center of a courtroom, and some other part of me had been protecting myself from admitting how far my own parents were willing to go, because as long as I hadn't looked directly at it, I could still tell myself there was a version of this where they came to their senses. There wasn't. The Ackerman thread was in there, the $10,000 payment routed through the Vance Family Foundation, dated April 21st, 8 days before the home visit. But it wasn't the only thing Chloe had captured. Buried in a forwarded email chain from March 30th, 10 days before my parents ever sat at my kitchen table, was a message from Victoria to Arthur with a subject line that read simply, "Trust language, Lily." Victoria to Arthur, confirmed with counsel. If Lily's primary residence changes to yours before her 7th birthday, I retain full discretionary authority over her trust allocations until age 25 instead of 18. Julian doesn't know this clause exists. Don't let his attorney find the 2019 amendment before the hearing. I read that line 4 times. Lily's 7th birthday was August 14th. The custody petition had been filed April 14th, exactly 4 months before that deadline, timed with a precision that had nothing to do with love and everything to do with a calendar Victoria had clearly been watching for over a year. "There's a 2019 amendment to the trust," Denise said slowly, more to herself than to me. "This changes what we're litigating. We're not just fighting a custody case anymore. We're fighting a financial motive with a paper trail attached to it, and if that amendment exists the way this email describes it, a judge is going to want to know why nobody disclosed it." She was right, and finding it took 11 days, because trust documents aren't public record the way court filings are. Denise subpoenaed the Vance family trust records through a discovery motion filed May 15th, which Ferris and Kane fought for 6 days before a judge, not Mercer, a discovery magistrate named Judge Torres, ordered partial disclosure on May 21st. What came back was a 43-page amendment, executed in December 2019, 6 months after Arthur sold his brokerage stake, naming Victoria as successor trustee with expanded discretionary authority specifically triggered by a minor beneficiary's change in primary residence. The amendment had one more detail Denise circled twice in red. It included a bonus structure. If Victoria managed the trust's investment portfolio, and it grew by more than 4% annually over any 5-year period while a minor beneficiary resided with a trust-designated guardian, Victoria was entitled to an annual management fee of 2% of total trust assets. On an $800,000 trust with anticipated growth, over 12 years, that fee structure could pay Victoria more than $300,000 before Lily ever touched a dollar of her own inheritance. Victoria wasn't defending a family decision. Victoria had built a business model around my daughter's custody arrangement. I confronted no one. Denise was firm about that. Nothing tips a case faster than a target realizing they're caught before the reveal is locked into a filing. Instead, on May 27, she filed an emergency motion requesting the court compel a forensic review of all communications between Arthur Vance, Evelyn Vance, and Victoria Preston relating to the custody petition, citing the flash drive contents as probable cause for tampering with a court-appointed evaluator. Judge Mercer set a hearing to consider the motion for June 9, not the final custody hearing yet, but close enough to it that Ferris and Kane suddenly stopped returning Denise's calls as quickly as they had before. Something else happened in that gap, something I didn't expect. On June 3, 6 days before the hearing, my phone rang with a number I didn't recognize. It was Marisol Ackerman. She didn't apologize, not exactly. She told me, in a voice that sounded like someone reading a resignation letter out loud for the first time, that she'd learned the consulting fee from the Vance Family Foundation had been flagged in an internal audit, and that a colleague on the foundation's board, someone with no stake in my case at all, had asked her directly whether the payment was connected to an active custody matter. She said she'd lied to that colleague. She said she couldn't keep lying once a judge started asking the same question under oath. "I'm not proud of my report," she said. "I'll tell you that much. I won't tell you anything else without my own attorney present." I didn't need her to say anything else. Denise subpoenaed her financial records the next morning. By June 8, the night before the hearing, we had the flash drive, the trust amendment, the foundation payment records, and a police report from Officer Reyes documenting the harassment of a minor. Chloe sat at our kitchen table that night, the $80 table, the one my parents had once sat at like they were closing an acquisition, and asked me a question I still think about. "Are you scared?" she said. I told her the truth. I was terrified, not of losing, but of what it would mean for her to watch her own grandparents exposed in a room full of strangers, to understand at 13 that people who were supposed to love her unconditionally had priced her sister at $3 million and priced her own silence at a boarding school tuition. That kind of knowledge doesn't leave a person. It reshapes them. Chloe looked at me for a long moment. "I'd rather know now," she said, "than find out later that everyone let it happen quietly." I didn't sleep much that night. Neither, I found out later, did Victoria, because at 1:14 a.m., her phone lit up with a message from Arthur that would end up read aloud in open court less than 12 hours later. "If this goes badly tomorrow, we need to talk about what you knew and when. I'm not taking this alone." Family courtroom for B smells like old carpet and hand sanitizer, and I remember thinking, sitting there at 9 a.m. on June 9, that a room this ordinary was about to decide whether my daughters stayed together. Arthur and Evelyn sat 2 rows behind their attorney, dressed like they were attending a charity gala, instead of a hearing about coerced testimony and a bribed evaluator. Victoria wasn't there yet. Her attorney, a younger associate from Ferris and Kane, kept checking his phone. Judge Evelyn Mercer entered at 9:04 a.m., and she has a particular way of scanning a courtroom before she sits down, like she's already deciding who's going to waste her time. Denise had filed our emergency motion under seal 4 days earlier, which meant Ferris and Kane knew something was coming but not exactly what. Their lead attorney, Rosalind Ferris herself, opened by arguing the flash drive evidence should be excluded as improperly obtained, since Chloe was a minor accessing message threads without explicit consent from every party involved. Judge Mercer let her finish. Then she asked a single question that reframed the entire hearing before it had properly started. "Ms. Ferris, are you telling this court that a 13-year-old preserving text messages sent directly to her own phone constitutes improperly obtained evidence, while your client's allegedly wiring $10,000 to a court-appointed evaluator does not concern you at all?" Ferris didn't have a clean answer. Denise moved to admit the evidence under the affidavit Chloe had signed with a court-appointed child advocate present, and Mercer allowed it, over continued objection, ruling that the public interest in evaluating potential tampering with a court officer outweighed the procedural concerns Ferris had raised. What happened over the next 90 minutes, I've had to piece back together partly from memory and partly from the transcript Denise later gave me, because I was so far outside my own body by that point that entire stretches of it come back to me in fragments. The Ackerman payment came up first. Denise entered the foundation's wire transfer records, dated April 21, $10,000 routed to an account linked to Marisol Ackerman under the label Consulting Services. Ackerman herself wasn't in the room. She'd retained her own attorney and submitted a sworn statement instead, admitting she'd accepted the payment 8 days before her scheduled home visit, and that specific incidents referenced in her report, including the January dentist appointment and the school parking lot description, had been provided to her in advance by Evelyn Vance rather than independently observed or verified. My mother's face didn't move through any of this. My father's did. He kept glancing at Victoria's empty seat. Then Denise projected the texts onto the courtroom monitor, one at a time, and the room went a particular kind of quiet I've never experienced before or since, not silence exactly, but the sound of a dozen people simultaneously recalculating what they thought they knew. Arthur to Victoria, the message from the tablet notification, laid out in full, instructions to route $10,000 through the foundation, specific incidents to feed Ackerman, dated 8 days before the visit that was supposed to be independent. Evelyn to Chloe, the foster care threat, time-stamped April 28, a grandmother telling a 13-year-old a lie designed to frighten her into betraying her own father. And then the one that changed the room entirely, Victoria to Arthur, March 30, the trust language email. Judge Mercer read the line about Lily's 7th birthday out loud herself, slowly, the way a person reads something they want a room to fully absorb. If Lily's primary residence changes to yours before her 7th birthday, I retain full discretionary authority over her trust allocations until age 25 instead of 18. She looked up from the monitor directly at my parents. This is not a custody petition, she said. This is an asset acquisition with a 6-year-old attached to it. My mother's attorney tried to object. Judge Mercer overruled it before the word left his mouth. Victoria arrived at 10:47 a.m., 43 minutes late, and walked directly into the tail end of her own trust amendment being read aloud to a packed courtroom. She stopped in the doorway. Her attorney tried to intercept her before she reached the gallery. She didn't listen to him. She sat down next to Arthur, and I watched her realize, in real time, exactly how much of this had already been said before she got there. Denise's final piece of evidence was the simplest and the worst for them. The 1:14 a.m. text from Arthur to Victoria, sent the night before the hearing, "If this goes badly tomorrow, we need to talk about what you knew and when. I'm not taking this alone." Denise didn't editorialize when she entered it. She didn't need to. A father, 12 hours before a hearing about his granddaughter, was already negotiating who would take the fall. Judge Mercer took a 15-minute recess before issuing her ruling, and when she came back, she spoke for 11 minutes without notes, which Denise told me afterward was unusual for her. She dismissed the custody petition with prejudice, meaning Arthur and Evelyn could not refile it. She referred the matter to the Fairfield County State's Attorney's Office for investigation into witness tampering and bribery of a court officer, naming Arthur, Evelyn, and potentially Victoria as subjects. She ordered a full independent audit of the Vance Family Trust, specifically the 2019 amendment, citing evidence that its structure may have created an undisclosed financial incentive to interfere with a minor's custody arrangement, a finding that would later trigger a separate civil action from a co-beneficiary I hadn't even known existed, a cousin on my father's side named Desmond who'd apparently been quietly excluded from the trust's original 2011 draft. Then she issued a protective order, not the temporary kind, the kind meant to last. It barred Arthur, Evelyn, and Victoria from unsupervised contact with Lily and Chloe Vance, effective immediately, reviewable in 18 months only through a formal court motion demonstrating a change in circumstances. "Mr. Vance," she said to me, and it took a second to register she meant me, and not my father, "I'm sorry your family made you fight this hard to keep your own children. That should never have been necessary." I didn't cry in the courtroom. I cried in the hallway 40 seconds after the doors closed behind us, with Denise's hand on my shoulder and Chloe standing next to me holding my other hand the way she used to when she was 6 years old and scared of an escalator. We didn't see my parents again that day. Arthur was arraigned on bribery and witness tampering charges 11 days later, on June 20th. Evelyn's charges followed a week after that, once the state's attorney finished reviewing the foundation's financial records. Victoria was never criminally charged. There wasn't enough to prove she'd known about the Ackerman payment specifically before it happened, but the trust audit stripped her of successor trustee status entirely, and the last time I heard anything about her, through a cousin who still talks to that side of the family, she and Preston had moved to Charlotte. Lily is 7 now. She doesn't remember most of this, and I've made a decision, one I go back and forth on some nights, not to explain the details to her until she's old enough to ask specific questions rather than absorb a story secondhand. Chloe remembers everything. She still has the flash drive. Actually, Denise gave it back to her after the case closed, and Chloe keeps it in a small box on her dresser next to a photo of her mother, not because she needs the evidence anymore, but because she says it reminds her that she was the one who didn't stay quiet when staying quiet would have been easier. I used to think revenge meant winning something back. I don't think that anymore. What we got back wasn't money or vindication. It was a locked door between my daughters and the people who tried to price them, and some doors are worth more locked than any amount someone once offered to open them.